Laura's got a secret, oh what a tale. She spins a wild story, sets sail without a sail. Fake baby bumps, she's got tricks up her sleeve, but the boys see through it, they just can't believe. Oh Laura, 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 what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise. Points her finger, you're the bad guy now. But truth's got legs and it's taken a bow. Her plans unravel like a thread on a spool. Life's not a game and you're breaking the rules. Lies and lawsuits, so what a show. But justice is coming, it's starting to grow. You can't win hearts with tricks or a fight. The truth shines brighter than a starry night. Remember, don't twist what's true. Life's much better when you just be you. Laura's learning the hard way it seems. Honesty's the hero in everyone's dreams. Oh Laura, oh Laura, Laura, what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all.
Heyo, folks. Just as everything was cooling down, thought I would take a few days off regarding live trial streaming. I'm actually probably not going to stream the Courtney Clenny case. I need to catch up on other cases, look into other trials, and the Courtney Clenny trial is stacked of dozens and hundreds of trial streamers that is going into it, because it's an OnlyFans. She did the stupid. There's bad facts hanging around. But I mean, we just got the Afro Man trial and the Kelsey Fitzsimmons trial. I wanted to rest on these positives for a bit regarding live trial streaming, and then get catching up on other things like this one. Serial pregnancy scammer Laura Owens, current former attorney David S. Gingras, is facing disciplinary in the Arizona State Bar, and he's fighting it. I mean, I don't mind anyone fighting disciplinary actions. It's how he does it that I have an issue with, because it's not good, David. It really isn't. You're making serious allegations against people, and then instead of actually showing what you have, you make insane allegations and you provide it to me. Well, you still have to have a reasonable. It still has to be reasonable. Ask ask of the Arizona State Bar. Well, I need to talk to this one. Okay, why? Because of this. Okay, you need some underlying facts here that you allege. Well, it has to be like this because of that. But all of those are pure speculation. What's your actual evidence that is even remotely reasonable? I will find out. I demand subpoena. And it's and and then now he has the power to subpoena, but it also has to be done right. So the first document we're going through is when David S. Gingras writes to subpoena Judge Mada's father, Harry L. Howe, a retired judge. Office of the Presiding Disciplinary Judge, filed 03/13/2026, so it is a couple of weeks ago. Harry L. Howe, Esquire, before the Presiding Disciplinary Judge in the matter of a member of the State Bar of Arizona, David S. Gingras. Objection 2. A motion to quash subpoena juris tecum. Harry L. Howe, pro per, pursuant to Rule 47, Rules of the Supreme Court of Arizona, hereby respectfully objects to the subpoena juris tecum served upon him by respondent David S. Gingras. On Monday, March 9th, 2026, at approximately 8:30 p.m., undersigned was served at home with a subpoena juris tecum. And it's a requirement to appear. Yeah, basically. Issued at the request of respondent, a true and a correct copy of which is attached hereto as Exhibit 1. Rule 47H3, Rules of the Supreme Court of Arizona, provides that a non-party who has been subpoenaed may file a written objection to the subpoena. The subpoena, Exhibit 8, hereto provides, you are hereby directed to appear and attend before and or respondent's counsel at this address on March 9th, 2026, then and there to testify in the above entitled matter and to bring with you the following, all documents described in Exhibit A hereto. He was served at 8:30 p.m. on March 9th, asked to be at this place earlier that day. Yeah, Mr. Dave Gingras, you served him the evening of the day you asked him to appear. Okay. Yeah, he's asking of this retired judge to appear as a time traveler. Exactly, Denise. No time of day on March 9th for the appearance was provided in the subpoena. So technically, the remaining 3.5 hours was what Gingras had intended. I say yes, this is regarding the bar complaint against Gingras. Obviously, being served with a subpoena at 8:30 p.m. the evening of March 9th with the commanded appearance and production date the same day, made compliance impossible. Furthermore, no time of appearance was even provided. Quite clearly, a reasonable time for compliance was not provided. The subpoena was accompanied by a letter from respondent, ostensibly dated February 27th, 2026, which stated it was sent by US Mail and Personal Service. That letter was never received through the mail and was first received at the time of personal service. The complete letter is not attached because it contains statements and allegations not properly before this disciplinary body. However, in part, the letter stated, the subpoena also directs you to personally appear, but at this time, you do not need to appear. You only need to produce the requested records. So, Mr. Gingras, you subpoena, which means you have to appear. And then you write, no, you don't have to, but produce the records. Oh. Directing that no personal appearance was necessary, which is inconsistent with the subpoena, does not obviate the simple fact that the subpoena called for appearance and production of documents on March 9th, time not specified, the same date as the subpoena was served. Additionally, Exhibit A to the subpoena contains 5 very broad categories of documents requested to be produced. Undersigned is not privy to the allegations in the disciplinary complaint, nor any answer/response filed by respondent. Therefore, undersigned, who is obviously a non-party to this proceeding, is unable to determine if any of the requested documents, should there be any such documents, are relevant to the issues of the proceeding, or reasonably designed to lead to the discovery of relevant admissible evidence. Undersigned, therefore respectfully request that the presiding disciplinary judge require respondent demonstrate clearly and credible, without speculation or unfounded accusation, the discoverability of the listed documents. To the extent that your undersigned possesses any documents as described in Exhibit A to the subpoena, requiring a non-party to produce private documents, should be done only upon a showing that such documents are indeed discoverable. Yes, mispronounced name, he definitely had to appear via the medium of non-appearance. So not only the demand from Mr. Gingras is that he time travels and not appear. Wherefore, Harry L. Howe, proper, respectfully moves for an order quashing the subpoena duces tecum, and upon the assumption that a valid and unobjectionable subpoena will be hereafter served, for an order requiring respondent to demonstrate the relevance of any documents requested, or that any such documents are reasonably designed to lead to the discovery of relevant admissible evidence. Dated March 13th, 2026. And this is where he signed everything. Let's see here. And this is the subpoena, which David Gingras. You're hereby directed to appear and attend before and or respondent's counsel, address, then and there to testify in the above entitled matter, and to bring you with you the following: all documents described in Exhibit A hereto in bold. Be warned that For failure to appear and attend as herein required, you will be deemed to be in contempt and answerable in court as provided by these rules. By the order of the presiding, what? Disciplinary clerk. If this date does not provide sufficient time to produce the information requested by this subpoena, a reasonable amount of additional time will be provided upon request. If you need to request additional time to respond, please call David Gingras at this or send an email to this. La-di-da-di-da-di-da. I'm not... This seems weird. So, David Gingras, via the disciplinary clerk, sends something with this language? Well, let's just say, if it's faked, I'm sure they will have, and I haven't heard anything about this it being faked. I'm just weirded out in the language used here. You do this in responding to the subpoena, blah, 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 blah. Yeah, it's just... this is just wordings. So, yeah. Exhibit A, documents to be produced. All requests cover the period from August 1st, 2023 to the present, unless otherwise stated. Copies of all correspondence, including emails, text messages, online chats, direct messages, etc., sent to or received from any person, excluding only your spouse, if any, relating to or which mention. This is overly broad. Laura Owens, Clayton Eckert, Greg Gillespie, Michael Marcini, Greg Wunick, David Gingras. Why do everything mentioning Arizona Commission of Judicial Conduct and the Owens v. Eckert case? Copies of any documents you received from any person, including but not limited to pleadings note. So, all of it. All of it. Copies. Okay, this is overly broad. But in here, there's a very, very major thing missing. What makes David S. Gingras suspect that Howard has this information? There has to be an underlying fact allegation that makes it, at least to some low degree, probable that the respondent, how Harry has this information, but he doesn't make any such upon normally upon what do you call it, upon information and belief. Linz, this is a stalling tactic he uses. Yeah, I know. He just files it all the damn time. Okay. So let's get to, before the 0323. So what this is 2 weeks later. Now 10 days later. He files this. This is from David S. Gingras. Respondent David S. Gingras respectfully moves for an order compelling two non-party witnesses, Julie A. Mara and their father, Harry Howe, to comply with subpoena served on them. Introduction. The court has 3 discovery motions to consider. This motion to compel and 2 motions to quash. These motions may appear at first to raise simple discovery disputes. In truth, the outcome of these 3 motions will have a major, almost certainly dispositive impact on the case. To avoid confusion, before discussing other issues, it is important to be extremely clear what this motion is not intended to do. It is not intended to act as a veiled attempt to get the court to change its prior rulings regarding records respondent sought from the Commission of Judicial Conduct. This point is important, so it will be addressed first. Yeah, I read Judge Mara's last time. This is over a month ago. Last time, her Judge Mara's motion to quash. So you have to jump back. you have to check the playlist because it's in there. Let's see here. Dun, dun, dun. And here is the footnote. Mr. Howe and his daughter, Judge Mara. No, this is not how you address 2 attorneys. By Mr. Howe and his daughter, Judge Mara. Be respectful. I know David S. Gingras, he is mentally unable to do that, but I will say it anyways. Have also separately moved to quash the 2 subpoenas. In the interest of creating a clear record, you have no interest in that. Rather than treating this motion as a response to the motion to quash, respondent will file a separate brief in response to both motions, even though there is admittedly some overlap between the briefs. Which translates to David S. Gingras saying, I'm going to repeat myself. But he wants the order. Yeah, you have to comply before he answers to the motion to quash, which has to be ruled upon before an order can be made. So it's oh, let's continue. 2 weeks ago, on March 6th, respondent filed a motion to compel, seeking records held by the CJC. On March 11th, the PDJ issued an order denying the motion. Yeah, fuck off. In that order, the court quoted from the bar's complaint, which accuses respondent of making false statements regarding a judge. After quoting the bar's allegations, the court summarily stated, respondent Gingras has not demonstrated how the outstanding items in the subpoena would assist in his defense regarding such. Yeah. Cue the clown music. Do I have it? Oh. Special effects. Where were we? Yeah. Later that same day, on March 11th, respondent moved for relief from the order denying the motion to compel. In that motion, respondent asserted the PDJ's decision appeared to have been based on argument that was never raised in the CJC's objection, i.e. that the records in questions were not relevant. To my recollection, I mean, the PDJ's decision is they can use whatever part of the bar allegation and whatever in the rules they want to say fuck off in lawyer speak. So Respondent then explained the CJC records were plainly relevant to the issue of whether his comments about Judge Mara were true or false. Yeah, he said it because it is his opinion, and therefore, because that is his opinion, which he bases out of absolutely nothing. But if if he can subpoena the judge and her father, somehow that will affirm his opinion with absolutely jack shit, nothing to back it up with. Respondent explained truth, falsity is a central issue in this case because, as multiple courts have held, attorneys may be sanctioned for impugning the integrity of a judge or the court only if their statements are false. Yeah, Mr. Gingras, if you make claims out of thin air, you have to show before you subpoena that there is some reasonableness to that allegation, to the things you said about them. And you don't. And Convy Jagman, Green. Truth is an absolute defense to any statement made by an attorney that impugns the honesty or integrity of a judge. Yeah, but you still have the responsibility for the reasonableness of your allegation. It's an extremely low bar to get to discovery. But you don't even reach that because it's my opinion that this is true. That's basically what Gingras tries to get subpoena through. After the respondent explained the CJC records were relevant, the following day on March 12th, this court issued a second order affirming the court's position that respondent was not entitled to obtain records from the CJC. In that order, the court explained respondent's point about relevance was misplaced, i.e., because the court indicated the motion to compel was not denied on that basis. The court further explained the order to quash granted relief because of the confidential designation that the Arizona Supreme Court has given the documents in question under the CJC rules. Yeah, you can't get things out of the CJC if you cannot show that the rules do not apply. And you couldn't. You just gave vague opinions. To be very clear and to put this as politely and respectfully as possible, you are still not mentally able to do any of those. Respondent disagrees with the court's legal conclusion. No. You do? In his prior pleadings, respondent noted confidentiality is not a valid basis for withholding otherwise relevant information. there is no absolute privilege for trade secrets and similar confidential information. So he uses a trade secret ruling for him to be able to basically defame the judge and her father. That the Arizona Supreme Court agreed with this ruling, calling it Stores v. Superior Courts. In that case, a party refused to answer interrogatories on the grounds they asked for information of a highly confidential nature. But the CJC is not that type of an entity. This does not apply. This does not apply. The Supreme Court rejected the argument and held confidentiality was not a valid basis to withhold otherwise relevant information in discovery. Instead, a party or witness holding confidential information must produce it subject to a protective order if warranted. And then quotes, blah, 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 blah. Similarly, in U.S. v. Nixon, the U.S. Supreme Court unanimously held a non-party witness, even the President of the United States, could not withhold relevant evidence sought by subpoena on confidentiality grounds. In that landmark ruling, the court was loud, clear, and unequivocal. Yeah, asshole. There was evidence presented to the court that Nixon had the information. And then Nixon tried to apply confidentiality, but the baseline here is that there actually was evidence, not thin air. Blah, 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 blah. Yeah. Having said this, to avoid any misunderstanding, respondent is not asking the PDJ to revisit, reconsider, or otherwise change the two prior rulings related to the CJC records. The PDJ has spoken on that issue. At the same time, these points are mentioned because it is possible the court may believe the current motion implicates the same confidentiality issue, even though it does not. So we are now at page 5, where you went through something this motion isn't. Here's why. The subpoena issued to Judge Mara requests much of the same information responded asked the CJC to produce. That's certainly true, as Judge Mara's motion to quash begrudging, which Judge Mara's motion notes. But that does not mean this court has ruled on the separate question of whether Judge Mara is required to comply with respondent's subpoena. Even though you told me no, I want to say if he's still required to do it because I want to. Again, because this issue is a little subtle. No, it isn't. Let's be very clear as to the CJC records. This court denied respondent's request to obtain those records because it's concluded that CJC's confidentiality rules provided a valid basis the CJC to withhold this information. Respondent understands the court's ruling, but respectfully disagrees with it because you're a fucking moron. And here's the thing. Since the CJC apply the confidentiality, they don't need to show basis of anything else. No, you can't have anything. It's under these confidentiality rules. They don't have to, which means you cannot claim. Well, they didn't say this, So this means now she has to comply. No, they don't have to do anything else. No, the rules say we don't have to. The same confidentiality argument does not apply to Judge Mara. I'm quite sure she didn't even claim that. Nothing in the CJC rules provides that the judge against whom a complaint has been filed may subsequently withhold otherwise relevant information in response to a subpoena, such as the judge's written response to that complaint, simply because the response was also sent to the CJC. The CJC rules say no such thing. But you have, we are now, page 5, you still, to this day, have not made the upon information and belief argument with a statement, this is why I believe this. This is why I believe the information is correct. No such thing. Because once he does, it falls apart. That argument, if raised, would be like claiming a client involved in an auto accident could refuse to answer any questions about the accident just because the client later discussed the incident with a lawyer. What? That, of course, is an incorrect statement of law, although attorney-client privilege protects a client's discussions with counsel. Oh, you're talking about civil. Okay. Although attorney-client privilege protects a client's discussion with counsel and shields no specific conversation from disclosure, the privilege does not shield any of the underlying facts simply because they are shared with a lawyer. Yeah, but Mr. Gingras, you still have the underlying fact in your example. There was an auto accident involving that person. There are underlying facts that makes it discoverable. You don't have any underlying facts. See Rs 122234. Explaining attorney-client privilege does not permit party to be relieved of a duty to disclose the facts solely because they have been communicated to an attorney. Yeah, so the point here is simple. This court denied respondents' request to obtain records from the CJC. It did so because the CJC rules say records held by the CJC are confidential. Judge Mara is not the CJC, and the motion to court does not claim she is entitled to withhold information on the same grounds as the CJC. No, yeah, exactly. So you have to overcome those. So while respondent respectfully disagrees with the PDG regarding the prior rulings related to the CJC, Judge Mara is in a different position. As such, this court should reach a different result. It should order her to comply with the subpoena by producing all evidence that is relevant and non-privileged. The same is true with respect to respondents. We are on page 6, and now he's touching in on this, on what he claims. Yeah, it's word salad. It's word salad. The same is true with respect to respondents' requests for records from Judge Mara's father, Mr. Howe. The information sought from Mr. Howe is directly relevant to the issues in this case. It is not privileged, nor is it even arguably confidential. The only argument Mr. Howe raises is that he is a non-party, and as such he is unable to determine if any of the requested documents are relevant. That's not exactly what he says. Let's see here. Here, let's see here. Here. Here is what retired Judge Howe writes. Additionally, Exhibit A to the subpoena contains 5 very broad categories of documents requested to be produced. Undersigned is not privy to the allegations in the disciplinary complaint, nor any answer response filed by respondents. Therefore, undersigned, who is obviously a non-party to this proceeding, is unable to determine if any of the requested documents, should there be any such documents, are relevant to the issues of the proceeding or reasonably designed to lead to discovery of relevant admissible evidence. Why is that? Why is that? Well, Mr. Howe is a non-party. And the information that Mr. Gingras seeks is regarding Judge Mara. So, and what he seeks is so overly broad, it's ridiculous. He has to show in his filings that there is a reasonableness to the allegations that Judge Mara and her father has this information. Not just say, it is clear. Not just say, upon information and belief. You have to argue something that by its reasonableness can lead to discoverable information. And he doesn't. This is not a valid objection, either factually or legally, but that is not exactly... So here is something that Mr. Gingras does. He quotes, and then he removes context. Discussion. Both subpoenas seek relevant information. The State Bar has charged the respondent with making false statements impugning Judge Mara's integrity. Among other things, respondent accused Judge Mara of violating the Code of Judicial Conduct by performing an extrajudicial investigation into the facts of Owens v. Eckert by making a factual finding that was not based on admitted trial evidence, and which was based on information Judge Mara obtained from an ex parte source. That is your claim. Your claim is that Judge Mara discussed the case with her father with zero evidence this happened. Zero, absolute zero. Other than Mr. Howe visited the courtroom. That is not evidence of an ex parte meeting. Folks, remember the YSL trial? The evidence of the ex parte meeting between the prosecutors and Woody. When Attorney Steele stood up and confronted Judge Glanville about this, his information and belief was a source. A source he refused to answer who it was. And Judge Glanville admitted on the stand they had an ex parte meeting without disclosing it to the defense. That's there you have underlying facts. It happened. Here, the only thing that Mr. Gingras says, this have to have happened because Mr. Howe visited the courtroom and nothing else. And his claim information obtained from an ex parte source is, in my opinion, out of thin air. Out of absolute thin air. And it's agreed by having an ex parte discussion about the case with her father, Mr. Howe, which included sharing pleadings from the case with him and discussing those pleadings with him. This is hallucinations from Mr. Gingras. There is zero evidence this ever happened. Even at the extreme low bar of upon information and belief. Zero. The details of respondent's accusation against Judge Mada was set forth in a 21-page affidavit filed on July 8th, 2024 in Owens. Yeah, that is your affidavit, which is part of why you are in front of this disciplinary committee. That entitled Affidavit of David Gingras in support of petitioner's notice of change of judge for cause, which he filed after. As that affidavit explained, immediately following the trial in Owens, multiple witnesses gave video recorded statements claiming Judge Mada's father, Mr. Howe, secretly attended the trial and told spectators he was not there to support his daughter, but rather he had been hearing about the case and was here for the circus. Really? To my recollection, what he quotes here is himself. He quotes himself asserting this in that motion with no underlying facts that these words was ever spoken. At least one witness claimed Mr. Howe said he had been discussing Owens with his daughter, that she has printed case-related documents for him, and that she had discussed those documents with him. These recorded statements are available to view on respondent's website. Let's see here. Oh.
I ran into Judge Mada's dad in the parking lot afterwards.
Oh no. Oh.
And I asked him, like, well, what did you think? He's like, I got to show you something. So he whipped me papers in his hand. And did anybody, I haven't been online really today, but did anybody, I saw kind of briefly that it was denied, this request for findings of fact and conclusions of law and proposed findings.
That wasn't denied.
That was not denied. Okay. So anyway, did anybody get a copy of this? He was saying, Julie told me this is just, you, Dad, you got to read this, and printed out a copy for me.
It's up by Owen and company.
Really?
Yeah, Judge Mata's dad was in the court with us.
Judge Mata's dad
was in the court with
No
in
way.
the side room where we were. Judge Mata's dad was sitting there.
She did fantastic.
I said, Harry, that's really nice. You want to be here to support your daughter? He said, oh, no, I've been hearing about this. I'm here for the circus.
Hold on, we don't need a mistrial.
Yeah.
Well, I mean, we could get him some scones.
Yeah, scones. We just heard.
I have not seen that. I must admit. Where were we? So, okay. So, according to a third party, her father said this. Yeah, yeah. Thank you, Linz. Wouldn't that mean he needs to subpoena that person first. Bruce, hey Bruce. So I spoke to different attendees who said that during the break they gave the judge's dad a copy of the pre-trial motion, which was publicly available because it had interesting quotes from Woodnick. Thank you. So I think there is some confusion about who gave this man a pre-trial filing on paper. Okay, thank you for the context. Thank you for the context, Bruce. Yeah, so what Gingras needs to do is not subpoena Judge Mara or her father. Well, this is strange, because I do see, mixed into all of this, I do see a reason to have, but he already has this information. Okay, now I need to think about this, because the worst thing I want to do is publicly say that Mr. Gingras has a point. What I do believe is yeah. Yeah, none of the attendees that they even knew what her father even looked like, so some joker could just be talking shit. Yeah, definitely. But that has to be asserted by that person, which is the person in that clip. Which I don't know who it is. Other witnesses state that the paperwork was given to him in line by them, not by the judge. Dun, dun, dun. All right, I need to think about this. I need to think about that. Let's keep going. Despite this, after investigation for more than 7 months, the CJC somehow determined respondents' allegations were not supported by clear and convincing evidence. However, the CJC has refused to reveal anything about how it reached that conclusion and has refused to disclose any evidence it considered. Despite filing charges accusing respondent of making false statements about Judge Mara and her father, the State Bar has disclosed no evidence of any kind to support that charge, other than a disclosure statement indicating Judge Mara has denied any wrongdoing, again with zero explanation. Now, here's the underlying facts here, which Mr. Gingras gets completely wrong. He claims ex parte meeting. He's very clear in that. But every piece of evidence says that somebody else gave him that. And a third non-party made a statement on a stream that he said this: I'm here for the circus, etc. He needs to, He needs to get himself a lawyer doing this instead of filing this shit. Because in this case, is there this slimmer of hope that he could actually subpoena? Yeah. But not through how he does it. Because he makes special allegations of an ex parte meeting. And an ex parte meeting in this situation is that the meeting was exclusively about this case, not something that was just mentioned in passing by. So it's just poorly written. In this posture, there is clearly a factual dispute where respondent's allegation about Judge Mata and the father true or false, as noted above. The lawyer cannot be disciplined for publishing true statements criticizing a judge. Yeah. But this is not the only, first of all, it's not the only thing in this which you have made claims about. You made, yeah, we need to remove the judge. Here's my evidence. And then it was denied, made a complaint, was denied because it didn't reach the level needed for a disciplinary action or needed for removing her as a judge. Lawyer cannot blah, 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 blah. The subpoena to Mr. Howe seeks relevant, non-privileged evidence. The subpoena respondent sent to Mr. Howe asked him for two main categories of documents. Correspondence he has exchanged with anyone regarding Owens v. Richard, overly broad, you have to narrow that, which would include email text messages exchanged with his daughter, Judge Mata, and two, correspondence he exchanged with the Commission of Judicial Conduct regarding his daughter, Judge Mata. Overly broad. It has to be narrowed down. Yeah, I agree. It's all hearsay. I agree. But hearsay can lead to discoverable information if written correctly. And Mr. Gingras is mentally unable to do so. So it seems like in this specific, when it comes to did you have an ex parte meeting, he needs to get himself a lawyer and not represent himself, because this is a clear example of a fool having a fool as a client while representing himself. Considering the specific allegations made by the State Bar against respondent, those two categories of documents are relevant because they bear directly on the issue of whether respondent's statements about Judge Mata were true. Mr. Howe does not assert privilege, nor does he claim the volume of response documents is so large as to constitute an undue burden. He also does not claim the information is not proportional to the needs of this case. He doesn't make any of those claims because he doesn't have to. Mr. Howe's relevance objection should be overruled. Again, let's go back. It contains 5 very broad categories of documents requested to be produced. Undersigned is not privy to the allegations in the disciplinary complaint, nor any answer response filed by respondents. Therefore, undersigned, who is obviously a non-party to this proceeding, is unable to determine if any of the requested documents, should there be such documents, are relevant to the issues of the proceeding or reasonably designed to lead to the discovery of relevant admissible evidence. These are the things Gingras has to overcome. And so far, all he does is, I wanna. First, because the requested information is relevant, you need to narrow it down to even come close to having success in this. Second, as the US Supreme Court held over 100 years ago, non-party witnesses cannot raise relevance objections for exactly this reason. This is not Blair v. US, 1919. This is regarding a grand jury subpoena. So it's not the same situation. It doesn't apply. A grand jury witness is not entitled to set limits to the investigation which the grand jury may conduct. This is not a grand jury. Oh, for fuck's sake. While no Arizona decision has directly applied Blair to a bar discipline case, exactly. That's your issue here. The Court of Appeals in Hawaii issued an extremely helpful decision on the closely analogous facts. In Sameshima vs. Yamashiro, a lawyer filed a complaint accusing a government official of violation of the Code of Professional Responsibility, the Hawaii Constitution, the Hawaii Revised Statutes, and the Hawaii County Charter by reason of conflicts of interest. The government official, the councilman, obtained a subpoena requiring the lawyer to appear and answer questions about his allegation. The lawyer appeared but refused to answer questions on 3 grounds: relevance, privilege, and work product. Citing Rules 26 of the Hawaiian Rules of Civil Procedure, which is identical to Arizona's rule, the trial court rejected all 3 objections and held the lawyer in contempt. The Court of Appeals affirmed, citing Blair. Blah, 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 blah. Now, the Arizona can take judicial Arizona State Bar can take judicial notice, but since it's not an Arizona case law, they don't have to do shit. The Court of Appeals also held any privilege objection was waived because the lawyer placed the privileged information at issue by using it to support his allegations against the councilman. This court should follow the same logic. The only objection Mr. Howe has raised is that he cannot determine whether respondent subpoena seeks relevant information. Even if relevance was a valid objection, which is not, that standard is easily met here. Respondent subpoena only seeks documents which bear on the truth of the statements in dispute. As such, the court should issue an order compelling Mr. Howe to comply in full with the subpoena. And then Judge Mara's objection. So it has to be narrowed down. This here is just mouthwash. His argument should be separated between Judge Mara and Mr. Howe. There's no way to get around it. But he mashes everything together to get a filing done. And then blah, blah, blah. Yeah, let's go to State Bar response. Reply. Oh, no, that's... okay, now, so, and then this is his actual response to motions to quash filed by Harry Howe and Julie Mara. Bad thing number 1. They have filed separately. You fucking answer separately. Idiot. Let's see if there's anything different here. It is it's the same shit. Basically. It's the same shit. Reply to State Bar's motion for judgment on pleadings in the matter of a member of the State Bar of Arizona. The State Bar of Arizona, by undersigned Bar Counsel, submits this reply to the State Bar motion for judgment on pleadings. Introduction. A. Responded. This, I feel there's something missing here. Hold on. Dun, dun, dun. Dun, dun, dun. Second motion to compel. Reply to State Bar motion for judgments on pleadings. This is so much shit in here. Sorry. So this, the March 23rd and March 24th by David Gingras, for obvious reasons, has not been responded to or responded to yet, for obvious reasons. It will be interesting to see how they answer to that, because I'm not from Arizona. I'm not even from the United States. But somewhere buried in David Gingras' motion, if handled by a competent attorney, there is a slimmer of chance for discovery. But since Mr. Gingras is a blabbering fool, he loses it by arguing the wrong things. So, let's go into this. Reply to State Bar's motion for judgment on pleadings. This is filed by the Bar Counsel. Introduction. Respondent's motion contains significant information introduction. Respondent's motion contains significant information wholly relevant to attorney discipline cases. Arizona attorney discipline cases are sui generis. The proceedings are expedited and therefore by necessity limited to issues relevant to the allegations of attorney misconduct. The pending motion identifies the pertinent admittal, factual allegations, and 6 findings for the related ethical violations, specifically incorporated into attorney discipline proceedings pursuant to Rule 48B. As explained more fully below, respondent failed to offer any relevant legal basis to defend his actions and instead argues that he would rather continue litigating the dismissed underlying state court cases in this attorney discipline matter. Yeah. What we spent the first hour doing is Mr. Gingras desperately trying to avoid the fact that he saw Laura Owens lie on the stand, knowingly allowing it to happen, which is against the rules for an attorney, which by itself is enough for disciplinary action. Yes, Nick longs to come to the United States. Please helping out, says JKD Book. Yeah, folks. In the future, I hope to relocate to the United States. In order to do that, I have to overcome the fact that I will be turning down my government pension, which means I need the funds. So if you can find it in your heart and wallet to support this channel, now monetary, I'll be happy to receive it. Not necessary, but always appreciated. As I always say, if you're choosing between bread and me, choose bread. I'm not asking for that. But if you are the type of person who goes to Starbucks a couple of times a day, one of them, a $5 or something. Why in the world would you want to come here to the United States? The First Amendment. That's it. The First Amendment. Over here, where I am, it is illegal to insult a civil servant. An employee of the state is illegal to insult. Last year, a 16-year-old was convicted of calling a police officer a cocksucker. Now, that was overturned on appeal, not because it wasn't illegal to call a police officer a cocksucker, but because there were several police officers around and they could not show that he called a specific cop a cocksucker. That's the only reason why it was overturned. So it's still illegal to call a specific police officer a cocksucker. First Amendment, folks. First Amendment. Randy, what about Canada? There may or may not the guns. Let's just say somewhere in the neighborhoods of the Appalachians is somewhere, because it reminds me of where I grew up in Sweden. I want to have a cottage with, of course, very good internet, where I can be left alone doing my streams, talking to you guys, and when I'm done, go out in the backyard and fire some rounds. I can't do that here either. So it's legal to scream out that all cops are trash baconators, but not a specific one who's wearing a bacon-scented shirt. Yeah, more or less. Cape 8 times. So this attorney is trying to defend his lies himself. Yeah. Gotcha. Well, that sounds like a lovely goal. We will welcome you. Just not used to people wanting to come to the US. Yeah. But folks, at the moment, just watch my videos. It has a little ads in them. Get my numbers up there, and more people will find my shows. All right, let's continue. As explained fully below, respondents failed to offer any relevant legal basis to defend his actions and instead argues that he would rather continue litigating the dismissed underlying state court cases in this attorney discipline matter. Factual basis remain undisputed. Superior Court requires a knowing mental state. Knowing, known, or knows denotes actual knowledge of the fact in question and may be inferred from circumstances. Respondent's response offers no legal dispute that he knew that the February 21st, 2024 court order unambiguously stated, "Let the record further reflect that no party shall disclose outside of themselves any medical or other documentation, exhibits, medical records, etc., disclosed between the parties." See amended complaint and amended answer, jointly referred to as CNA, blah, 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 blah. See also respondents' response at page 9. Despite his actual knowledge of the court's prohibition, respondent nevertheless filed a motion attaching his signed declaration and including 3 medical records. Nick email. There you have it. Santa Claus chasing tornadoes would be wild. I'm not going out chasing tornadoes. So Oklahoma, in Oklahoma, hey MD, in Oklahoma you could have all that and plenty of land to farm. Plus we could chase tornadoes. It would be rather the other way around, that tornadoes would be chasing me. I'm considered a large object, and tornadoes seems to like hovering and tossing around large objects. Now, I'm not cow-sized. I mean, I'm not like 1,000 pounds, but I am at 300. Yeah, so he filed a motion including 3 medical records, despite the court's order saying, no, you cannot. Posted Sonora Quest Laboratories medical records online. Yeah, this is good. The footnote here. Respondent attempts to create a straw man, alleging that the State Bar believes that the order requiring a protection order before filing medical records or other documents, while respondent should have obtained a protective order, sought relief from the court, or taken some actions to ensure his compliance with the order does not contain requirements as to how the parties should comply with the plain language of the prohibition. See also Rule 60, Arizona Revised Civil Pro, blah, blah, blah. So, yeah. Oh. What's going on here? Thank you to Ambrosia over at Rumble for $5 Rumble Rant. Our free speech here is under huge attack as well, but I agree, not as bad as Europe or Australia. I don't drink Starbucks ever. Thank you so much, Ambrosia. That is so, so nice of you. Yeah, but the difference is that you have the First Amendment, so you can fight back. We don't have it here. We don't have a First Amendment. All that is needed is the ruling party saying, yeah, we want this. Let's make a law. Like they did here. With basically 0 discussions regarding how good this is. I believe they've had, if it was just before our Congress winter break, the day before they went on winter break, they voted on this law. They were handed the law. They handed the law out like the day before the vote, full well knowing that most of people in the Congress wasn't there. And then 6 months later, it was written into law. But thank you so much. Thank you for your help. 3. Respondent also knew that opposing counsel informed him of his violations on February 21st, 2020 of his violations. Despite his admitted actual knowledge of the foregoing, respondents repeatedly violated the unambiguous prohibition by posting portions of another medical records online, filing another document which included medical records and excerpts from expert medical reports prepared for the opposing party, posting a copy of his filed document as well as the attached medical records and excerpts from the expert reports online. Respondents' multiple violations of the course prohibition by repeatedly disclosing medical records and other documents violated Rule 42, Arizona, revised, blah, 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 blah. Respondent admits making certain statements regarding Judge Mata, the contents of which speak for themselves. Respondents affirmatively alleged that every statement he made regarding Judge Mata was factually true, or was made with good faith basis to believe it was true, or was an opinion protected by the First Amendment to the United States. While respondent attempts to justify his unapologetic violations of his professionalism, and ethical obligations, respondent suggests that his misconduct is constitutionally protected. The Arizona Supreme Court disagrees. Ambrosia over at Rumble asks, what percentage of a Rumble rant goes to you? I can check, actually. Sorry, I had to sneeze. Dashboard. Transactions. Let's see here. Of a $1 Rumble rant, I get 77 cents. So 23, the Rumble takes 23%, which is less than YouTube, who takes 30. Dun, dun, dun. Yeah. So it seems 23% is Rumble's. Yeah. The First Amendment rights of attorneys. A lawyer is held to a narrower standard of free speech than a non-lawyer when discussing the judiciary. A member of the bar can and will be stopped at the point where he infringes our canon of ethics. And if he wishes to remain a member of the bar, he will conduct himself in accordance therewith. The objective standard of review rendering respondent's subject opinion of truth irrelevant. Yeah, so him claiming there's an absolute, he has an absolute true or false, that is not the standard for attorneys. And then footnote. While respondent's response mentions the reported Seaman case identifying similar unprofessional behavior, respondent fails to address the factually unrelated Seaman attorney discipline case. Yeah. Respondent's general beliefs and reasons. In his response, the respondent offers the following. Multiple material facts are in dispute. The bar's position is directly contrary to controlling law, and the bar has moved for judgment offensively. Multiple facts are in dispute. The opposite is true. All the relevant facts in support of this motion were unequivocally admitted in respondent's answer and amended answer. Yeah, he self-snitched. He self-snitched. Respondent erroneously believes that the previously adjudicated facts in the underlying state court cases and his relentless campaign to continue maligning the judiciary should be the subject of this attorney discipline case. The bar position is directly contrary to controlling law. Respondent repeats the following in various forms throughout his response. Prior requests for confidential orders in the underlying case, all which predated his representation, were denied prior to the February 21st, 2024 court order. The language of the orders is too vague. Opposing counsel also engaged in misconduct. The state bar is violating the anti-SLAPP law. As to the first claim, courts are authorized and frequently do alter, revoke, amend, affirm, overrule, clarify, and reverse orders throughout the pendency of lawsuits. Prior rulings, which were later negated by written order, do not provide a defense or other justification for respondents' knowledge and repeated violations of the valid February 21st, 2024 order. As to the respondent's second claims, incredibly, respondent, an Arizona attorney of almost 22 years, suggests that the plain and unambiguous language of the order is simply too vague to be understood, as it did not contain the word "it is ordered," or use language specifically sealing the prohibited documents. The court ordered no medical records be publicized outside of the parties. As to respondent's third catch-all claim of wrongdoing by others, the named complainants and the potential witnesses are not parties to this attorney's discipline matters. None of these beliefs are accurate or state a legal dispute to the motion. Conclusion. Respondent has admitted the relevant actions and fails to provide a legal dispute that his actions complied with the Arizona rules of the Supreme Court. Therefore, an evidentiary hearing on the admitted facts and resulting violations serves no purpose. Accordingly, the state bar requests that the court enter a judgment against respondent for his violation of the cited ethical rules. What they do here is actually amazing. Because what they do is taking this, that Gingras, he keeps, yeah, I need this information from Judge Mara and her father. Yeah, but that is not necessary for you to be disciplined. If I have any, yeah, I have. Hold on here. I have PayPal. Dun, dun, dun. Let me pin that message. PayPal. Now, PayPal only takes like 5 to 6%. I also have Buy Me a Coffee. And let's see. Oh, I almost did the wrong thing. Dun, dun. I also have Buy Me a Coffee. I should have that as a banner all the time. Let me create a banner. Add banner. Done. There. So on the top of the chat or in the chat, you have the PayPal. And up here on the scrolling thingy, you have my Buy Me a Coffee. And they only take 3 to 4%, I believe. And they don't take it from you. They take it from me when I extract money from them. Yeah, Apple is a flat 30% no matter the platform. Yeah, I know. Apple sucks donkey balls. Apple sucks donkey balls. So, folks, when it comes to this matter of David Gingras' disciplinary actions, as explained here by let's see here. There. By the state bar attorneys. what he tries to extract from Judge Mara and her father has no effect on the state bar proceeding. He has admitted to a lot of things that he did. Oh, thank you. Thank you so much. That is so nice of you. Yeah, I can see it here. Thank you so much. Thank you so much. Thank you. This brings me a bit on the way. Now, generally, what happens to the money you send over here is, first I have to take care of the costs of running this channel. First of all, I have to pay my taxes on it, then cover the costs of this channel, and usually what I use the proceeds is that I take a vacation to the United States or Canada. This year it's probably going to be Canada. And but also, if there's anything left, it goes into a savings account where I put it in funds and stocks, with the hope of it growing enough for me to say, screw you, the Swedish government, I'm off. Yeah, and thank you to everybody who added to GD's birthday fund. Thank you so much. I have sent it over. It got up to $56, I believe. All right. Yeah, but as Dee said, he's just stalling. He is just stalling. He throws in motion of the motion of the motion of the motion. And he does that because he represents himself. If he got himself representation, they would tell him to grovel. Get on your knees, apologize, throw yourself at the mercy of the bar, and hope for the best. But no, he makes shit worse. He makes shit worse. And in the end, it won't matter. I do believe that soon-to-be former attorney David S. Gingras will be disciplined. Now, what can he be disciplined with? That is another interesting question, because he can be said he has a fine, pay it. Or he can be get a few months of non-practice. No, you are on leave. You have to tell all your clients, which is probably one, that you cannot represent them in any way, shape, or form. And then hand over that case, regardless of if it is pro se on quid pro quo, pro se, regardless if it is an unpaid position or not. And which could be trouble for Laura Owens. Or he could lose his license. Pro bono. Thank you, Jinx. Pro bono. So it can go from a fine all up to losing his license. Now, I've seen in the periphery some of these cases passing by where somebody gets disciplined, and it varies. Some, when it is about money, low amounts of money, it almost exclusive. Yeah, you can practice for 3 to 6 months, up to 2 years. If it is large amounts of money, they lose their licenses. Doing what he does here generally spans between pay a substantial penalty or 3 to 6 months off. You can practice law. Sadly, what he does here, with the exception of all his ramblings, happens frequently. It happens frequently. And so I do believe, even though I hope he loses his bar license, I think that there needs to be more. But oh wait, there is more. There's a DUI case. His second DUI case pending at the moment, which he also stalls desperately. Because if all of this happens roughly at the same time, which it does, then the bar can take everything into account, and that can make it worse. Yeah, over at Rumble, I can't do Rumble Wallet, badly. I wish I could, but I can't. Oh. Do I have anything else to say? Not at the moment, but it will be interesting to see the replies from Judge Mara and her father to his latest shenanigans. Her trial starts soon, Laura Owens. Let's see here. July 20. Okay, so it's not soon. July 29th is the new date. A plea deal was offered that expires on April 24th. I don't think she'll take that. I almost know she won't, because her lawyer that she had recused himself after the plea deal was offered. So I assume he said, take it. And she said, fuck you. And he said, well, then I'm out, because I can't defend you. I think I covered the plea deal in the last time I did a video. Last time I did a stream. I can. Where is it? Dun, dun, dun. Owens criminal case. There it is. No, I don't have that. I don't have that paper. I don't have that paper. All right, folks. That is what I had for you for this time. Now, folks, I'm going to send you over to Defense Diaries. Why? They are going to make the State v. Defense on the Richard Allen appeal. For the defense, Andrea Burkott and Ali Mota. For the state, Michael Ausbrook. That will be a highlight. That will be amazing to watch, because as the stream I did Saturday into Sunday morning was the state has replied to Rick Allen's appeal brief. And it's absolutely horrifyingly bad. But in the hands of a competent attorney like Michael Ausbrook, it will be really, really interesting to see how he handles the arguments in there. And for the defense, you have Andrea Burkhart, who's specialized in appeals work. Specialized on appeals work. So, yeah, that starts in about 20 minutes. So I'm going to send you over there. Now, regarding the Laura Owens case, when something new happens, I will cover it. If something happens during it that I don't know, I will try to find out. Yeah, she still does appeals work. Yeah. Thank you for reminding me. Keep 8 times. And yeah, Laura Owens case, definite. I will cover that from gavel to gavel, as I usually do. I won't cover the Courtney Kennedy case. I need to get caught up with the other things I cover. And Laura Owens in July, that will be interesting. And all the other cases I cover. Old Line Red, I saw that reply. The current AG of Indiana is a former client of Old Line Red. Oh, don't say anything. We'll see what shows up. We'll see what shows up that I can cover. But this week, I might do a Judge Simpson reaction stream where we just watch Judge Simpson and do some commentary and have fun together. A couple of those maybe. And some videos. And yeah, let's see. But it will be fun. It will be interesting. I will try to do my best to entertain and educate and inform. So thank you, guys. Thank you for allowing me to do this. Thank you for you. Because without you guys, this would not happen. Thank you. And I will see you guys in the next stream or video. Have a good one. Bye-bye.
Laura's got a secret, oh what a tale. She spins a wild story, sets sail without a sail. Fake baby bumps, she's got tricks up her sleeve, but the boys see through it, they just can't believe. Oh Laura, 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 what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise. Points her finger, you're the bad guy now. But truth's got legs and it's taking a bow. Her plans unravel like a thread on a spool. Life's not a game and you're breaking the rules. Lies and lawsuits, so what a show. But justice is coming, it's starting to grow. You can't win hearts with tricks or a fight. The truth shines brighter than a starry night. Remember, don't twist what's true. Life's much better when you just be you. Laura's learning the hard way it seems. Honesty's the hero in everyone's dream.